Alright, I'm going to try to finish up this judgment on the case of ES v. Austria. This is where I left off yesterday, relevant domestic law. I'm going to get into that now. So Article 188 of the Criminal Code is part of Section 8 of the Criminal Code, which inter alia lists criminally punishable offences against religious peace. It reads as follows. So, to be clear, this is Austrian law. Whoever, in circumstances where his or her behavior is likely to arouse justified indignation, publicly disparages or insults a person who, or an object which, is an object of veneration of a church or religious community established within the country, or a dogma, a lawful custom, or a lawful institution of such a church or religious community, shall be liable to up to 6 months imprisonment or a day fine for a period of up to 360 days. So let's break that down. So it's behavior that is likely to arouse justified indignation or publicly disparages or insults a person or an object, that's an object of veneration, or a dogma, a lawful custom, or lawful institution of such a church or religious community. And especially with the addition of the word dogma. I mean, a dogma in the Islamic faith is that Muhammad ascended to the heavens on an ass. A dogma of the Catholic faith is transubstantiation, or the Trinity, or the unity of the Trinity, or whatever. I mean, publicly disparaging or insulting a dogma, or posing behavior that's likely to arouse justified indignation. Behavior towards a dogma. And that's how far a law like that reaches. That's the law that she was actually found guilty under. This next article, 283, incitement to hatred, is the thing that she was originally charged under, but which was basically dropped and lowered down to Article 188. So 283 reads as follows. 1. Whoever, in a manner capable of endangering public order, publicly incites to commit a hostile act against a church or religious community established within the country, or against a group defined by its belonging to such a church or religious community, a race, a nation, a tribe, or a state, shall be liable to up to 2 years imprisonment. Similarly, whoever publicly incites against a group defined in paragraph 1 or tries to insult or disparage them in a manner violating human dignity shall equally be held liable. Okay, so paragraph 1. If you publicly incite to commit a hostile act against a church or religious community or a race, a nation, tribe, state, whatever, in a manner that's capable of endangering public order, then you can be held liable for up to 2 years imprisonment. That is relatively reasonable. Any law can be abused, naturally. It all depends on the people that are enforcing it, that are legislating around it. But this is something that, at least on the face of it, doesn't immediately strike me as something that, I mean, you're publicly inciting to commit a hostile act. That, I mean, a lot would depend on what you mean or what you call a hostile act. But I mean, if we're going to throw these guys a ball and assume that it involves violence, then this is a reasonable limit on your freedom to act, your freedom to express yourself. But then the second paragraph says whoever publicly incites against a group defined in paragraph 1 or tries to insult or disparage them in a manner violating human dignity. Now, what does that mean? If I were to say that anybody that truly follows Muhammad's example is a piece of shit and not really all that worthy of the name human being, if we're going to apply this in any kind of positive fashion, then is that a insult or disparagement in a manner violating human dignity against a group belonging to a group belonging to the church or religious community? Probably. But what am I doing wrong with that? If I were to say it means such a thing. So, international material. Article 20, Section 2 of the 1966 United Nations International Covenant on Civil and Political Rights provides that any advocacy of national, racial, or religious hatreds that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. Now, there we have it. I mean, violence, any advocacy of national, racial, or religious hatred that constitutes incitements to violence shall be prohibited by law. Acceptable. Acceptable. This hostility, that's blurring the lines. But then adding discrimination, I mean, and then what does advocacy of hatred entail? Once again, if I were to say if we should not engage with or do business with people that behave in a certain way, then that's probably inciting to discrimination. And that's apparently not allowed. Why am I not allowed to incite people to discriminate against assholes? You know, not to do business with assholes, not to be nice to assholes, to just, call them out for being assholes and be like, all right, you be all the asshole you want to be, but the consequences are going to be that I'm not going to do business with you. Let people make their own goddamn choices. And carry their own goddamn consequences. All right, next paragraph. The Council of Europe Parliamentary Assembly stated in its recommendation 1805 on blasphemy, religious insults, and hate speech against persons on grounds of their religion. With regard to blasphemy, religious insult, and hate speech against persons on the grounds of their religion, the state is responsible for determining what should count as criminal offences within the limits imposed by the case law of the European Court of Human Rights. In this connection, the Assembly considers that blasphemy as an insult to religion should not be deemed a criminal offence. A distinction should be made between matters relating to moral conscience and those relating to what is lawful, matters which belong to the public domain and those which belong to the private sphere. Even though today prosecutions in this respect are rare in member states, they are legion in other countries of the world. The Assembly notes that member states have the obligation under Article 9 of the Convention to protect freedom of religion, including the freedom to manifest one's religion. This requires that member states protect such manifestations against disturbances by others. However, these rights may sometimes be subject to certain justified limitations. The challenge facing the authorities is how to strike a fair balance between the interests of individuals as members of a religious community in ensuring respect for their right to manifest their religion or their right to education, and the general public interest or the rights and interests of others. The Assembly considers that, as far as it is necessary in a democratic society, in accordance with Article 10, Paragraph 2 of the Convention, national law should only penalize expression about religious matters which intentionally and severely disturb public order and call for public violence. So, the Assembly considers that as far as it is necessary in a democratic society, in accordance with Article 10, Paragraph 2, the clause of the Convention, national law should only penalize expression about religious matters which intentionally and severely disturb public order, which this did not do because there was one person that complained, and called for public violence. There was no call for public violence. There was no severe disturbance to public order. And yet they cite this in their judgment, which I find strange. Next section. 28. The European Commission for Democracy Through Law, the Venice Commission, stated in its report on the relationship between freedom of expression and freedom of religion, the issue of regulation and prosecution of blasphemy, religious insult, and incitement to religious hatred. As concerns the question of whether or not there is a need for specific supplementary legislation in the area of blasphemy, religious insult, and incitement to religious hatred, the Commission finds a. that incitement to hatred, including religious hatred, should be the object of criminal sanctions, as is the case in almost all European states. B. That it is neither necessary nor desirable to create an offense of religious insult, that is, insult to religious feelings, simpliciter, without the element of incitement to hatred as an essential component. C. That the offense of blasphemy should be abolished, which is already the case in most European states, and should not be reintroduced. I severely disagree with this adding hatred, which is much too vague a term, no matter actually how you choose to, I'm going to lower my volume a little bit, there we go. No matter how you choose to define it, it's not, it doesn't, I would have to be convinced to accept it as a workable legal and legislative term. But I am open to such convincing. So, as concerns the question of to what extent criminal legislation is adequate and or effective for the purpose of bringing about the appropriate balance between the right of freedom of expression and the right to respect for one's beliefs, the Commission reiterates that, in its view, criminal sanctions are only appropriate in respect of incitement to hatred, unless public order offenses are appropriate. Notwithstanding the difficulties with enforcement of criminal legislation in this area, there is a high symbolic value in the pan-European introduction of criminal sanctions against incitement to hatred. It gives strong parts to all segments of society and to all societies that an effective democracy cannot bear behaviors and acts which undermine its core values: pluralism, tolerance, respect for human rights, and non-discrimination. It is essential, however, that the application of legislation against incitement to hatred be done in a non-discriminatory manner. In the Commission's view, instead, criminal sanctions are inappropriate in respect to an insult to religious feelings, and even more so in respect to blasphemy. So the Venice Commission said criminal sanctions are inappropriate in respect to insult to religious feelings, which is one of the bases on which that law, that Austrian law, and the subsequent conviction of ES have been based upon. There's a lot of other stuff here, like, I mean, well, pluralism, tolerance, respect for human rights, and non-discrimination. It's so sad that many of these terms have gotten corrupted so badly that one almost has the automatic tendency to look for something bad in there. But pluralism, when it's about pluralism of ideas, of philosophies, is something that can greatly benefit a society, as long as it's exactly done in a tolerant way. As long as we tolerate, not accept, but tolerate those people with vastly different ideas as us. As long as that can be done in a framework of respect for human rights. Not necessarily human rights as defined in the Universal Declaration or European Declaration of Human Rights, but because those are way too positively worded. And non-discrimination, as in, I may not agree with you, but that doesn't mean that I'm going to exclude you from society. As long as there's this framework of tolerance, human rights, and respect for each other's ideas is there, then we can live in the same society and work towards some of those goals that we automatically share. We're human beings. There's some goals we automatically share. We don't want to be hungry. We don't want to be cold. We don't want our loved ones to suffer. So, the United Nations Human Rights Council stated in its resolution 1618, combating intolerance, negative stereotyping, and stigmatization of and discrimination, incitement to violence and violence against persons based on religious belief, adopted on 24th of March 2011. These people really don't have much better to do, do they? The Human Rights Council expressed its concerns that incidents of religious intolerance, discrimination, and related violence, as well as of negative stereotyping of individuals on the basis of religion or belief, continue to rise around the world, and condemns in this context any advocacy of religious hatred against individuals that constitutes incitement to discrimination, hostility, or violence, and urges states to take effective measures as set forth in the present resolution, consistent with their obligations under international human rights law to address and combat such incidents. 5. Notes the speech given by Secretary General of the Organization of the Islamic Conference at the 15th session of the Human Rights Council and draws on its call on states to take the following actions to foster a domestic environment of religious tolerance, peace, and respect by speaking out against intolerance, including advocacy of religious hatred and that constitutes incitement to discrimination, hostility, or violence. Sure, no problem. As long as that also includes people preaching hatred in a religious context, using their sacred text, which I apparently can't insult or disparage as a basis. Adopting measures to criminalize incitement to imminent violence based on religion or belief. Incitement to violence is illegal, as far as I'm aware. Adding more caveats or extra protected groups that will get you more punished than other groups, that to me seems like a very bad and illiberal idea and goes against the concept of blind justice. Understanding the need to combat denigration and negative religious stereotyping of persons, as well as incitement to religious hatred by strategizing and harmonizing actions at the local, national, regional, and international levels through inter alia education and awareness building. So, get all those different levels, local, national, regional, international, in line through basically propaganda campaigns to combat denigration and negative religious stereotyping of persons. And I mean, there's been religious unrest in a country like India for a long time. A lot of it has been silenced to death because many people don't dare speak out against some of the things that the Muslim groups have been doing there. And that's not to say that, for instance, the Hindu religious group has not been doing anything, but right now they're turning rather murderous. And though it's something that Hindus have been known to do in the past, they usually go murderous as a counter movement to something else. And if I read the news now, I'm seeing this Hindu religion painted as a bunch of murderous crazies. Well, what they're actually doing is they're counter-reacting to a hostile invader. Because that's how they see Islam. Because that's how Islam got into India. That's how India and Pakistan have been. I mean, Indians are pissed off at the fact that Pakistan, northern India, one of the more beautiful parts of India, has been ripped away from their country, and that unity, that sort of unity of people that there once was, has been fucked up. And if you look at the state of Pakistan, I mean, India's no walk in the park, but it's goddamn heaven compared to Pakistan. So, H. Recognizing that the open, constructive, and respectful debate of ideas, as well as interfaith and intercultural dialogue at the local, national, and international levels, can play a positive role in combating religious hatred, incitement, and violence. Yeah, that's true. Open, constructive, and respectful debate can be good. But just yelling at each other and calling each other doo-doo heads, and then just at the end of that, shaking each other's hands, can also be very productive. So, 30. The UN Human Rights Committee adopted on its 102nd session the General Comment number 34 on freedom of opinion and freedom of expression. 3. Freedom of expression is a necessary condition for the realization of the principles of transparency and accountability that are, in turn, essential for the promotion and protection of human rights. Defamation laws must be crafted with care to ensure that they comply with paragraph 3 and that they do not serve in practice to stifle freedom of expression. All such laws, in particular penal defamation laws, should include such defenses as the defense of truth, and they should not be applied with regard to those forms of expression that are not of their nature subject to verification. At least with regards to comments about public figures, consideration should be given to avoiding, penalizing, or otherwise rendering unlawful, untrue statements that have been published in errors but without malice. In any event, the public interest in the subject matter of the criticism should be recognized as a defense. Care should be taken by states parties to avoid excessive punitive measures and penalties. Where relevant, state parties should place reasonable limits on the requirement for a defendant to reimburse the expense of the successful party. State parties should consider the decriminalization of defamation, and in any case, the application of the criminal law should only be countenanced in the most serious of cases, and imprisonment is never an appropriate penalty. It is impermissible for a state party to indict a person for criminal defamation but then not proceed to trial expeditiously. Such a practice has a chilling effect that may unduly restrict the exercise of freedom of expression of the person concerned and others. So you have to go to trial expeditiously and not wait like, what was it, between 2008 and 2012 when the actual court proceedings started? Whatever. Prohibitions of display of a lack of respect for religion or belief system, including blasphemy laws, are incompatible with the covenant, except in the specific circumstances envisaged in Article 20, paragraph 2 of the covenant. Thus, for instance, it would be impermissible for any such laws to discriminate in favor or against one or certain religions or belief systems, or their adherents over another, or religious believers over non-believers. Nor would it be permissible for such prohibitions to be used to prevent or punish criticism of religious leaders or commentary on religious doctrine and tenets of faith. It's very strange that they choose to quote this right here, wouldn't you? Wouldn't you say? I mean, you'd almost say that they know what you were doing. It's almost like they're fucking doing it on purpose. 49. Laws that penalize the expression of opinions about historical facts are incompatible with the obligations that the covenant imposes on state parties in relation to the respect for freedom of opinion and expression. The covenant does not permit general prohibition of expression of an erroneous opinion or an incorrect interpretation of past events. Restrictions on the right to freedom of opinion should never be imposed, and with regards to freedom of expression, they should not go beyond what is permitted in paragraph 3 or required under Article 20. So here they're saying the expression of opinions about historical facts you cannot curtail, even if it's incorrect, erroneous in this context, or an incorrect interpretation of past events. Not acceptable, according to the UN Human Rights Committee. And when it comes to a lot of things, I'm not exactly a fan of the UN Human Rights Committee. So when I'm on their side on something, then I have to get past a pretty considerable amount of distaste for what they are and what they've done. But when it comes to that, I completely understand what you're saying here. It's a very necessary caveat, a very necessary paragraph to add. And once again, I find it very strange that it's included in this document, which just flat out ignores it. So, 31. The European Parliament's resolution of 27th of February 2014 on the situation of fundamental rights in the European Union held that the European Parliament recalls that national laws that criminalize blasphemy restrict freedom of expression concerning religious or other beliefs, that they are often applied to persecute, mistreat, or intimidate persons belonging to religious or other minorities, and that they can have serious inhibiting effects on freedom of expression, on freedom of religion or belief. Recommends that the member states decriminalize such offences. I find it strange that they're saying, oh yeah, it's bad because they're here. It shows you something very nice about European Parliament. Here they're saying, they could be interpreted as basically saying here, oh yeah, blasphemy laws are bad because they're often used to attack minorities. It doesn't fucking matter. If a minority is using it to attack a majority, it's just as bad as if the majority were using it to attack the minority. If one person were using it to attack 100 others, or 100 others one-on-one, it would still be the same problem in principle. And that is what matters here, because this stuff creates precedent. All right, next section, the law. Previous section in its entirety was called the facts. Alleged violation of Article 10 of the Convention. 32. The applicant alleged that her criminal conviction for disparaging religious doctrines had given rise to a violation of Article 10 of the Convention, which reads as follows. Everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. This article shall not prevent states from requiring the licensing of broadcasting, television, or cinema enterprises. 2. The cop-out clause. The exercise of these freedoms, since it carries with it duties and responsibilities, true, may be subject to such formalities, conditions, restrictions, or penalties as are prescribed by law and are necessary in democratic society in the interests of national security, territorial integrity, or public safety. For the prevention of disorder or crime? For the protection of health or morals? For the protection of the reputation or rights of others? For preventing the disclosure of information received in confidence? Yeah. Or for maintaining the authority and impartiality of the judiciary? Yeah. That I can understand. Though it's already way too late. Impartiality. Yeah. Right. The court notes that the application is not manifestly ill-founded, and within the meaning of Article 35, subsection 3a of the Convention, it further notes that it is not inadmissible on any other ground. It must therefore be declared admissible. Merits. 1. The party's submissions. The applicant considered that her conviction for the above-mentioned statements had amounted to an unlawful interference with her right to freedom of expression. Referring to the court's case law, she considered that domestic courts had failed to address the substance of the impugned statements in the light of Article 10 of the Convention. If they had done so, they would not have qualified them as mere value judgments. Value judgments were only excessive if they were not linked to facts, whereas her criminal statements had been based on facts. I don't get freedom of expression, but value judgments are excessive if they're not linked to facts. Why? Why can I not make any value judgment that I want? Why can anybody not make any value judgment that they want and express that? What is wrong with that? It's better to know these things than to have people walking around believing all kinds of crazy shit that you don't even know about. The applicant stated that by stating that Muhammad had had sexual intercourse with a 9-year-old, she had quoted a historically proven fact and questioned whether this could be regarded as pedophilia. Thus, she had based her value judgment on facts, which was always permissible within the meaning of Article 10 of the Convention. Furthermore, through the impugned statements, she had expressed criticism concerning Islam and the unreflected imitation of Muhammad in the framework of an objective and lively discussion, which the domestic courts had failed to take into account. Against that background, this had been an objective criticism of religion, had contributed to a public debate, and had not been aimed at defaming the Prophet of Islam. Consequently, contrary to domestic courts' reasoning, a sufficient factual basis had existed for her assessment that Muhammad's behavior had amounted to pedophilia. She added that she had held a seminar extending over a number of days with an overall duration of 12 hours. Therefore, a few individual statements had to be tolerated in order to allow for a lively discussion, which was a necessary part of such a seminar. The applicant further submitted that religious groups had to be regarded as public institutions and therefore had to tolerate even severe criticism, referring inter alia to the court's judgment in Aydin Tatlov and Gündüz versus Turkey. The applicant alleged that improper attacks on a religious group had to be tolerated even if they were based on untrue facts, as long as they did not incite violence. Moreover, the rights guaranteed under Article 9 of the Convention did not imply a ban on the propagation by others of a doctrine which was hostile to other people's faith. Only expressions that were gratuitously offensive to others, and thus an infringement of their rights, and which therefore did not contribute to any form of public debate, should be prohibited by law. Whereas blasphemy laws provided for a criminal sanction should be avoided according to international law standards. She contrasted her case with the court's IA, cited above, as the impugned statement that the issue in IA had not been linked to facts. Basically, you're saying here that is, I understand and I agree with a lot of the case that's being made here, but some of the case law that they are, or some of the international law that they are trying to use here is probably not a very good idea. Only expressions that are gratuitously offensive to others and thus an infringement of their rights, and which therefore did not contribute to any form of public debate, should be prohibited by law. So that would be a statement like "Gas the Jews." But then the problem becomes, what if it's a fucking joke? But that's beside the point right now. In relation to the question of the legitimate aim of the applicant's criminal conviction, the government submitted that Article 188 of the Criminal Code did not prohibit critical or offensive statements about a church or religious community per se, but merely regulated the manner in which such statements could be made. As the explanatory notes on the government bill stated, the primary purpose of that provision was to protect religious peace, which was an important element of the general peace within the state. Religious peace was to be understood as a peaceful coexistence of the various churches and religious communities with each other, as well as with those who did not belong to a church or religious community. The government concluded that the applicant's criminal conviction had pursued the legitimate aim of maintaining order and protecting the rights of others, namely their religious feelings. Then we read something in international law stating that you shouldn't or can't make laws to protect people's religious feelings. Oh well. The government argued that domestic courts had, in accordance with the court's case law, balanced in their examination of the impugned statements the rights of the applicant to disclose their views to the general public against the rights of others to respect for their religious freedom. Respect for your religious freedom. If I say your religion is shit and I don't like it, that does not impugn upon your religious freedom in any way, shape, or form. They had comprehensively addressed the substance of the impugned statements and concluded that they had not been part of an objective discussion concerning Islam and child marriage, but had rather been aimed at defaming Muhammad and therefore had been capable of arousing justified indignation. Government reiterated that the Supreme Court had accepted that the issue of adults having sexual contact with minors gave rise to a public debate about, and the limits of acceptable criticism were therefore wider. However, the applicant's statements in substance accused Muhammad of pedophilia and in that respect lacked sufficient factual basis. They were disparaging towards Muhammad and therefore had not contributed to an objective public debate. Referring to the court's case law, the government pointed out that critical statements regarded by believers as extremely insulting and provocative, as well as general vehement attacks on religious or ethnic groups, were incompatible with the values of tolerance, social peace, and non-discrimination, which underlie the convention, and therefore were not protected by the right of freedom of expression. Lastly, the imposed sanction had been a moderate day fine of €4, the legal minimum, for a duration of 120 days, thus only a third of the possible maximum period of 360 days. So, the government tries to cover their asses while basically saying the same things. The law is not a problem. Law number 188 is not a problem, because we're not saying, here, where is it? Article 188 did not prohibit critical or offensive statements about a church, but merely regulate the manner in which you can do so. It's not just the manner, it's the manner, the context, it's what you can say, how you can say it. That is the lamest fucking cop-out I have heard in this entire fucking document. Lame. Lame. And then they're talking again by the rights of others to respect for their religious freedom in a context which shows that they're not talking about that. They're talking about the right of others to have their fifis protected. Boing. Critical statements regarded by believers as extremely insulting and provocative, as well as general vehement attacks on a religious or ethnic group, are incompatible with the values of tolerance. They were not vehement attacks on a religious or ethnic group, and whether people think something is extremely insulting and provocative should not be a metric on whether or not it should be acceptable expression. It's really, really strange. And this flies in the face of the international law that has been cited above. So, 2. The third-party intervener, which was the European Centre for Law and Justice, submitted that statements which amounted to value judgment but were not devoid of any factual basis, contributed to a public debate, and did not immediately incite violence, were permissible under Article 10. It observed that criminal conviction which pursued the aim of protecting the belief itself rather than the believer's feelings was one of blasphemy. A criminal charge which, according to international law standards, should be abolished. It argued that Article 188 served as a deterrent, obstructing free debate, having recourse to criminal sanction rather than civil law. One, to protect freedom of religion was not necessary in a democratic society. So they don't like this law, the European Centre for Law and Justice, but they're saying that a criminal conviction to protect believers' feelings is not a blasphemy law. I would tend to disagree. I think. Oh well. So, 3. The court's assessment. The court considers, and this was common ground between the parties, that the criminal conviction giving rise to the instant case amounted to an interference with the applicant's right to freedom of expression. Such interference constitutes a breach of Article 10 unless it is prescribed by law, pursues one or more of the legitimate aims referred to in paragraph 2, and is necessary in a democratic society in order to achieve the aim or aims in question. A. Prescribed by law. The court notes that it was undisputed the interference had been prescribed by law, the applicant's conviction being based on Article 188 of the Criminal Code. B. Legitimate aim. While the applicant stressed that her statement had never been aimed at disparaging Muhammad, she does not dispute the legitimate purpose of criminal convictions under Article 188 of the Criminal Code, namely to protect religious peace. Mistake. Big fucking mistake. The court endorses the government's assessment that the impugned interference pursued the aim of preventing disorder by safeguarding religious peace, as well as protecting religious feelings, which corresponds to protecting the rights of others within the meaning of Article 10, subsection 2 of the Convention. So here apparently they have made an oversight, or the defense made an oversight, or a tactical mistake, no matter how you want to call it, and they did not dispute the legitimate purpose of criminal conviction under Article 188 of the Criminal Code to protect religious peace. Mayhaps that would have helped. Of course, hindsight is 20/20. And when they tell you what the name of the stick is to beat you with, well, yeah, of course you know what to look out for next time. C. Necessary in a democratic society. The court reiterates the fundamental principles underlying its judgments relating to Article 10 as set out, for example, in case law and case law. Freedom of expression constitutes one of the essential foundations of a democratic society and one of the basic conditions for its progress and for each individual's self-fulfillment, subject to paragraph 2 of Article 10. It is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb. The court notes that there is little scope under Article 10, subsection 2 of the Convention for restrictions on political speech or on debate on questions of public interest. Those who choose to exercise the freedom to manifest their religion under Article 9 of the Convention, irrespective of whether they do so as members of a religious majority or a minority, therefore cannot be expected to be exempt from criticism. They must tolerate and accept the denial by others of their religious beliefs and even the propagation by others of doctrines hostile to their faith. 43. As paragraph 2 of Article 10 recognizes, however, there we go, cop-out clause, the exercise of the freedom of expression carries with it duties and responsibilities. Amongst them, in the context of religious beliefs, is the general requirement to ensure the peaceful enjoyment of the rights guaranteed under Article 9 to the holders of such beliefs, including a duty to avoid, as far as possible, an expression that is, in regard to objects of veneration, gratuitously offensive to others and profane. See Segmandis Limited versus Lithuania from January 2018, which is case law. All this case law I'm going to look into, but that one is of particular interest to me. I'm going to mark it here again, even though I already have it in my reference sheets. That Segmandis Ltd versus Lithuania is what you're using here to say that one of your duties and responsibilities is to avoid as far as possible an expression that is in regards to object of veneration, gratuitously offensive to others and profane. Jesus. Where such expressions go beyond the limits of a critical denial of other people's religious beliefs and are likely to incite religious intolerance, for example, in the event of an improper or even abusive attack on an object of religious veneration, a state may legitimately consider them to be incompatible with respect for the freedom of thought, conscience, and religion, and take proportionate restrictive measures. In addition, expressions that seek to spread, incite, or justify hatred based on intolerance, including religious intolerance, do not enjoy the protection afforded by Article 10 of the Convention. In examining whether restrictions on the rights and freedoms guaranteed by the Convention can be considered necessary in a democratic society, the Court frequently held that the contracting states enjoy a certain margin of appreciation. The absence of a uniform European conception of requirements of the protection of the rights of others in relation to attacks on their religious convictions broadens the contracting state's margin of appreciation when regulating freedom of expression in relation to matters liable to offend personal convictions within the sphere of morals or religion. So there's no uniform European conception of these requirements, strangely enough. So they have a wide margin of appreciation, even wider than it already was. Not only do they enjoy a wide margin of appreciation in that respect, they also have the positive obligation under Article 9, but where? To ensuring a peaceful coexistence of all religions and those who do not belong in a religious group by ensuring mutual tolerance. Like that is one of the consequences of positive rights, especially positive human rights. What does that mean? Where is the limit of that scope? If it's a state's duty to ensure mutual tolerance, I would say it's a state duty to interfere when certain things start happening, when there's violence in between these groups. And it would most definitely, it would be a nice thing for a state to do to facilitate mutual tolerance and communication and such like that. But these words like ensuring, it just creates a massive fucking scope for these things, and it's insane. A state may therefore legitimately consider it necessary to take measures aimed at repressing certain forms of conduct, including the imparting of information and ideas judged incompatible with respect for the freedom of thought, conscience, and religion of others. It is, however, for the court to give a final ruling on the restriction's compatibility with convention, and it will do so by assessing it in the circumstances of a particular case. The issue before the court therefore involves weighing up the conflicting interests of the exercise of two fundamental freedoms, namely the right of the applicant to impart to public views on religious doctrine on the one hand, and the rights of others to respect for their freedom of thought, conscience, and religious on the other. I can respect your right to freedom of thought, conscience, and religion, and yet still not respect you, your thoughts, the contents of your conscience, or your religion in any way, shape, or form. That's completely doable. That's the old adage, though I disagree wholeheartedly with what you are saying, I will defend to the death your right to say it. But that apparently is not fucking good enough. In its case law, the court had distinguished between statements of fact and value judgment. The classification of a statement as fact or as a value judgment is a matter which first and foremost falls within the margin of appreciation of the national authorities, in particular the domestic courts. However, the court can change its classification when exercising its supervisory function. In previous cases, the court has emphasized that the truth of value statements is not susceptible to proof. The requirement to prove the truth of a value judgment is impossible to fulfill and infringes freedom of opinion itself, which is a fundamental part of the rights secured by Article 10. However, even where a statement amounts to a value judgment, the proportionality of an interference may depend on whether there exists a sufficient factual basis for the impugned statement, since even a value judgment without any factual basis to support it may be excessive. So, you can't be required to prove the truth of a value statement, but a value statement can still be excessive if you can't prove it. That's nice. As court has noted in previous cases, the difference lies in the degree of factual proof which has to be established. Oh, yeah. See, that's the thing. These people, they don't understand what the principle is. The principle that you have to prove the truth of a value statement is incompatible with freedom of expression, freedom of conscience, freedom of thought. The principle. So if you just fuck around with how much you're fucking with this principle, that is still against the goddamn principle. Oh, I'm only slightly torturing you. That's not the same as torture. Jesus. In exercising its supervisory function, it is not the court's task to take the place of the national authorities, but rather to review under Article 10, in light of the case as a whole, the decisions they have taken pursuant to their power of appreciation, particularly whether they base their decisions on an acceptable assessment of relevant facts. Take that in for a moment. So they have to just look at the facts, look at the case, and see what is the government's they don't take place of the government, they just look at the entire case and are like, was this reasonable enough? So, if it's an acceptable assessment of the relevant facts and whether the interference corresponded to a pressing social need and was proportionate to the legitimate aim pursued. In order to determine its proportionality, the courts must consider the impugned interference not only in the light of the content of the statement at issue, but also in the contexts in which they were made. Furthermore, the nature and severity of the penalty imposed are also factors to be taken into account. See, for example, Gunduz cited above, where the balancing exercise has been undertaken by the national authorities in conformity with the criteria laid down in the court's case law. The court would require strong reasons to substitute its view for that of the domestic courts. We're getting there. The court notes that at the outset of the subject matter of the instant case is of a particularly sensitive nature, and that the potential effects of the impugned statements, so it's of a sensitive nature because of the statements, not because of the fact that freedom of expression is under attack here. They don't give a shit about that. So the effects of the impugned statement, to a certain degree, depend on the situation in the respective country where the statements were made at the time and in the context they were made. Accordingly, and notwithstanding some of the domestic court's considerations, such as the duration of the marriage in question, the court therefore considers that the domestic authorities had a wide margin of appreciation in the instant case, as they were in a better position to evaluate which statements were likely to disturb the religious peace in their country. The court notes that the domestic courts considered the applicant's statements as having been made public. Indeed, the seminars were widely advertised to the public on the internet and via leaflets. The latter were sent out by the head of the right-wing Freedom Party, addressing them especially to young voters and praising them as top seminars in the framework of a free education package. The applicant's intervention was entitled Basic Information in Islam and was meant to be a critical analysis of Islamic doctrine, allowing for discussion with the participants of the seminar. The title gave the, in hindsight, misleading impression that the seminars would include objective information about Islam. Let's hold there for a moment. So once again, ECHR says wide margin of appreciation. Sensitive subject matter, but not because they are trying to infringe one of our most basic goddamn rights in relation to a minority. Yet again, they are once again pointing out that the Freedom Party is right-wing. They are claiming that the seminars did not include objective information on Islam, which we know at least 2 correct facts were mentioned there. 2 correct facts were mentioned there at the very least. And that, what else can you require for objective information about Islam? Zero value judgment? I mean, if somebody were to give a course, basic information on Islam, that's nothing, that's basically trying to convert you to Islam, and that wouldn't be a problem, according to these fuckers, would it? That wouldn't be objective information. And if I were to take offense to that and say it infringes upon religious peace, then I don't think I'd get very far with that, would I? Alright, so it appears that anyone interested was able to enroll. There was no requirement to be a member of the Freedom Party. The applicant could therefore not assume that there would only be like-minded people in the room who would share her very critical views of Islam, but had to expect that there could also be people amongst the audience who could be offended by her statements. It is of little relevance. Only 30 people attended on average. The applicant's statements were in fact recorded by a journalist who had participated in the seminar and whose employer subsequently reported them to the public prosecutor. So they want echo chambers. They want to enforce echo chambers. Saying something outside of an echo chamber is not legal anymore because somebody might take offense. As long as they're doing it on grounds of being some sort of minority, you cannot say anything about anybody outside of an echo chamber of people that agree with you. But you'll never find those people. You'll never find those people if you're not allowed to speak your mind. The court reiterates that a religious group must tolerate the denial by others of their religious beliefs and even the propagation of others of doctrines hostile to their faith, as long as the statements at issue do not incite hatred or religious intolerance. Come on, man. There's only one God for the Jews and the Christians and the Muslims, so by definition, their faith is incompatible with the others. You can't be a Christian and a Muslim at the same time. So those doctrines are, in a sense, hostile to each other. That doesn't mean that they can't coexist in a civilized, modern society. But that just means that this measuring stick you're holding is useless. Article 188 of the Criminal Code is in fact does not incriminate all behavior that is likely to hurt religious feelings or amounts to blasphemy, but initially requires that the circumstance of such behavior were able to arouse justified indignation. What's the difference between arousing justified indignation and hurting religious feelings? Therefore aiming at the protection of religious peace and tolerance. The court notes that domestic courts extensively explain why they considered the applicant's statements had been capable of arousing justified indignation, namely that they had not been made in an objective manner aimed at contributing to a debate of public interest. That's their value judgment, but could only be understood as being aimed at demonstrating that Muhammad was not a worthy subject of worship. Another thing that they are just claiming to be true. When saying what do we call it is not pedophilia, the applicant, according to her own statements, was quoting a conversation she had with her sister, who was of the opinion that one had to paraphrase the accusation that Muhammad was a pedophile, saying it in a more diplomatic way. The court notes the applicant herself, as an expert in the field of Islamic doctrine, already having held seminars of that kind for a while. Her argument that the impugned statements had been made in the context of a lively discussion where they could not be revoked anymore is therefore not convincing, contrary to what had been the case in Kunduz. The court therefore agrees with the domestic court that the applicant must have been aware that her statements were partly based on untrue facts and apt to arouse justified indignation in others. In that context, the court reiterates the Convention states are even required under their positive obligations under the Article 9 of the Convention to ensure the peaceful coexistence of religious and non-religious groups and individuals under their jurisdiction by ensuring an atmosphere of mutual tolerance. So we can't say anything. So you can't say anything about a religious group, but the religious group can say anything that they want. What's the difference? I mean, if somebody is advocating for Sharia law, why shouldn't that arouse justified indignation in me? And why isn't that the same? I don't want that to become illegal on the basis of the fact that that arouses justified indignation in me. But what's the difference here? What's the legal difference? I really don't understand. The court endorses the regional court statements and adjustment of 2011 that presenting object of religious worship in a provocative way capable of hurting the feelings of the followers of that religion could be conceived as a malicious violation of the spirit of tolerance, which one of the bases of democratic society. The court notes that domestic courts qualify the impugned statements as value judgments based on detailed analysis of the wording and of the statements made. Structural deconstructionism. They found that the applicant had just subjectively labeled Muhammad with pedophilia as a general sexual preference, only because you chose to change the definition of pedophilia, and that she failed to neutrally inform her audience of the historical background, which consequently did not allow for a serious debate on that issue. What? So the courts are saying here that they have some kind of standard about what kind of information that you have to impart on people before you can impart certain other information on them. But it's not like it's written down somewhere. I mean, it would be, if it were written down somewhere, it would be handy. Like, hey, you can't say that Muhammad was a pedophile unless you also say that, yeah, he also married a whole bunch of other fucking women that weren't minors. I mean, give us a list of things we have to say before we're allowed to say something. Then, if you really want it to be that way. But you know that if you were to do that, that'd be too honest, that'd be too open, then you couldn't use this as a stick behind the door. The court therefore agrees with the domestic courts that the impugned statements can be classified as value judgments without sufficient factual basis, even if they were to be classified as factual statements, which the applicant insisted she had failed to adduce any evidence to that end, both during the domestic proceedings and before the court. As to the applicant's argument that few individual statements had to be tolerated during a lively discussion, the court considers it is not compatible with Article 10 of the Convention to pack incriminating statements into wrappings of an otherwise acceptable expression of opinion, and to deduce that this would render the statements exceeding the permissible limits of freedom of expression passable. Moreover, the applicant was wrong to assume that improper attacks on religious groups had to be tolerated, even if they were based on untrue facts. On the contrary, the court has held that statements which are based on manifestly untrue facts do not enjoy the protection of Article 10. Lastly, the court reiterates that the applicant was ordered to pay a moderate fine of only €480 in total for the 3 statements made, although the criminal code alternatively would have provided for up to 6 months imprisonment. Furthermore, the fine imposed was on the lower end of the statutory range of punishment, blah, 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 and the domestic courts applied only the minimum, blah, blah, through the applicant had no previous criminal record, and this was taken into account as a mitigating factor. Her repeated infringement had to be considered as an aggravating factor. So the fact that she made 3 statements in 1 seminar is a repeated infringement. Congratulations! Under the circumstances, the court does not consider the criminal sanction as disproportionate. The court, in conclusion, finds that in the instant case, the domestic courts comprehensively assess the wider context of the applicant's statements and carefully balance her right to freedom of expression with the rights of others to have their religious feelings protected and to have religious peace preserved in Austrian society. So from now on, because the court has said so, people have the rights to have their religious freedom protected and the rights to have religious peace preserved, whatever the fuck that might mean. They discussed the permissible limits of criticism and of religious doctrines versus their disparagement, and found that the applicant's statements had been likely to arouse justified indignation in Muslims. Why can you not disparage religious doctrines? Why not? I can disparage religious doctrines and political doctrines. I can disparage scientific ideas, especially if I have a scientific basis for it. I can disparage all kinds of fucking things. What the hell is wrong with that? Why should it be the job of any kind of government, any kind of state institution to get itself involved in that? So, they discussed it. In addition, the court considers that the impugned statements were not phrased in a neutral manner, aimed at being an objective contribution to a public debate concerning child marriages. So, they are literally policing your tone, because it's not phrased in a neutral manner. They're saying that you have to make an objective contribution for which they hold standards, which they are not going to inform you of, basically. And they are saying that there's a certain list of topics which are in the public interest, which once again isn't really an actual fucking list, you know? It's a nebulous goddamn concept in their heads. And that they amounted to generalizations without factual basis. So apparently, the fact that it's in their own goddamn books, in their own goddamn jurisprudence, is not a factual basis. Feels equals reals. It offended them, so it's not true. It can't be true because it offended them, and they feel it's wrong. They feel it's wrong. Just like they would feel it's wrong to call Muhammad a butcher because he decapitated hundreds of people. Thus, by considering them as going beyond the permissible limits of an objective debate and classifying them as an abusive attack on the Prophet of Islam, which was capable of stirring up prejudice and putting at risk religious peace. Yeah, but by whom? The domestic courts came to the conclusion that the facts at issue contained elements of incitement to religious intolerance. The court accepts that they thereby put forward relevant and sufficient reasons, and finds that the interference with the applicant's rights in Article 10 indeed corresponded to a pressing social need and was proportionate to the legitimate aim pursued. Therefore, the court considered that the domestic courts did not overstep their wide margin of appreciation in the instant case when convicting the applicant of disparaging religious doctrines. Accordingly, there has been no violation of Article 10 of the Convention. For these reasons, the court unanimously declares the application inadmissible, holds that there has been no violation of Article 10 of the Convention, done in English, and notified in writing on the 25th of October 2018, pursuant to Rule 77, subsection 2 and 3 of the Rules of Courts. Claudia Westerdick as Registrar and Angelika Nussberger as President.